Hello everyone. My name is Teresa Straight. I am the new Vice President of Human Resources. Welcome to the first legal training class you will be attending as managers for the company. Each month we will consider the most common laws you will deal with as a manager. This month we will be covering the Civil Rights Act, Americans with Disabilities Act, Age Discrimination in Employment Act, Pregnancy Discrimination Act, Fair Labor Standards Act, Family Medical Leave Act, Equal Pay Act, and the Occupational Safety and Health Act. These monthly classes cannot comprehensively cover every aspect of each law, so if you have further questions or problems following this training, please refer to your manual and have a discussion with someone from HR. These laws and our company policies are designed to protect our employees and our company. We will have a question and answer period following this class this afternoon. All right, there is a lot of ground to cover, so let's get started in Employment Law 101. What is employment law? Employment law covers all rights and obligations within the employer-employee relationship, including current employees, former employees, and job applicants. Every manager has a shared responsibility with Human Resources, HR, to ensure every interaction with employees is compliant with federal and state employment laws. Under the law, our employees have the right to work in a safe workplace, to be free from discrimination and harassment, and to be paid fair wages for work performed. Employees have a right to privacy. This applies to personal possessions such as handbags, briefcases, and personal storage lockers. Managers may not search employee articles without permission unless it is provided by the contract of employment. Title VII of the Civil Rights Act of 1964 are the Equal Opportunity Laws. Title VII ensures all employees and job applicants are protected against employment discrimination. This act prohibits discrimination and harassment because of race, color, religion, sex, which goes beyond gender to include pregnancy, gender identity, and sexual orientation, national origin, age, disability, personal or family medical history, genetic information, political affiliation, or any other non-merit-based factor. All employees shall be free of harassment by managers, co-workers, or others in the workplace. No employee will experience retaliation because they filed a claim against the company, complained about discrimination, or assisted in the investigation of a claim or lawsuit. Let me inject a real-life example of this for you here. Chantel Charles, who is Haitian and African American, has been a longtime employee of the City of Boston, working as a senior administrative assistant at the Treasury Department. In 2011, she filed a complaint of retaliation and discrimination against the city, claiming she had been paid less than her Caucasian co-workers and received fewer benefits. When she complained about the wage disparity, her employer retaliated against her by giving her poor job evaluations. Charles ended up winning her case against the City of Boston and was awarded $10 million in punitive damages, $500,000 for emotional distress, and $389,000 in additional pay. As a manager, it is your responsibility to treat all employees and job applicants consistently and equally. Managers may not base employment decisions, opportunities for advancement, evaluations, or appraisals on protected characteristics. To avoid a real-life story like the one you just heard, you will not base evaluations on anything other than job performance. Managers will treat all employees respectfully to avoid unwelcome behaviors that constitute harassment. The Americans with Disabilities Act. The ADA prohibits discrimination based on a disability. The ADA provides that if an individual with a disability can perform essential functions with or without reasonable accommodation, that person can't be discriminated against on the basis of their disability. Employees and managers may not discriminate against qualified individuals with a disability in advertising, recruitment, job application procedures, hiring, promotions, transfers, seniority, termination, wages, leaves of absence, training, or any other job-related aspect. Under the Americans with Disability Act, all employers are required to provide reasonable accommodations. The ADA defines a reasonable accommodation as any change to the application or hiring process, to the job, to the way the job is done, or the work environment that allows a person with a disability who is qualified for the job to perform the essential functions of that job and gives the individual the ability to enjoy equal employment opportunities. Accommodations are considered reasonable if they do not create an undue hardship or pose a direct threat to the business. Managers must have the ability to recognize and respond to the need for reasonable accommodation for an employee or a job applicant. Managers will not deny a reasonable workplace accommodation needed by the employee due to disability or a religious belief. As a manager, it is vital that you establish an interactive process of discussion and problem solving with an individual to find the accommodation that fits the work situation. This may include flexible scheduling, improving accessibility to a work area, or assignment modifications. Additionally, it is critical for managers to work with HR to identify the essential job functions of the employee to discover which accommodations will satisfy the ADA compliance process. The Age Discrimination in Employment Act prevents employers from giving preferential treatment to younger workers. This only applies to workers 40 years of age and older. Managers must never use age in making employment decisions. It does not matter how close an employee is to retirement when making decisions regarding hiring, firing, training, promotion, or any other employment conditions. Managers must never replace an older employee with a younger one without a legitimate reason. Managers may not discipline older workers differently than younger workers or communicate in any way that implies an age bias. The Pregnancy Discrimination Act of 1978. The PDA prohibits discrimination based on pregnancy, childbirth, or any related medical condition. A woman may not be refused a job, fired, refused a promotion, or refused leave because she is pregnant, may become pregnant, or has had an abortion. Managers should treat pregnant employees the same as any other employee who has a temporary disability based on their ability to perform their job. If you would provide light duty for an employee who has had shoulder surgery, then you must make similar adjustments for a pregnant employee. Additionally, when the employee returns from pregnancy leave, she is entitled to return to the same job or a comparable job. Time for one more real-life example of what not to do as a manager. Rosario Juarez, an employee from the AutoZone in San Diego branch, brought a lawsuit against her former employee after being told by AutoZone higher-ups that she could no longer perform her job due to her pregnancy. She was demoted and eventually fired. In an unprecedented win in the fight against pregnancy discrimination and retaliation, AutoZone announced it would drop its challenge of a $186 million pregnancy discrimination verdict. The Fair Labor Standards Act, or FLSA, establishes the laws that cover minimum wage, overtime pay, and record keeping for both full-time and part-time employees. These guidelines must be followed to determine exempt or non-exempt status, not a job title. This means managers should work diligently with HR to define the work and responsibilities of each position, to ensure employees are paid in accordance with the hours worked, to keep our company within the law's provisions. The company is required to pay non-exempt employees for all work hours. Work hours are the time which the employee works for the company, even when not specifically directed to do so. The FLSA mandates that an employer must pay for work time if the employer has actual or constructive knowledge that work is being performed. Actual knowledge means you can see someone working at their desk during the workday. Constructive knowledge means realizing work has been performed due to an outcome, even when the work was not observed. An example of this is Joe. Joe has been informed the report he has been given to work on is due tomorrow. At 5 when he goes home, the report is unfinished. In the morning, Joe arrives with a completed report. Obviously, Joe worked outside his regular hours and must be compensated. As a manager, it is your responsibility to ensure all employees receive proper pay for all hours worked, particularly overtime. Managers are responsible for understanding which employees are exempt and non-exempt, and must consult with HR before making any changes to an employee's essential duties, as that could affect their exemption status. It is managers' responsibility to follow the law to ensure the company is paying for all work hours so that it is not in violation of the FLSA. Work hours also include all times the employer permits the employee to work, even off-the-record hours, which means work an employee performs at lunch, at home, or when arriving early. This law also stipulates non-regular work time that needs to be paid for, such as trainings, meetings, travel, or on-call. Managers must work closely with HR to clearly define what activities and time require compensation. Family Medical Leave Act, or FMLA, entitles all eligible employees to unpaid leave for up to 12 weeks per year for certain family and medical emergencies, and up to 26 weeks to care for wounded military family members. When the employee returns from leave, managers must work with HR to place the employee in the same job or a comparable job with the same terms and conditions of employment. As a manager, you must refer all requests for any medical leave to HR. You also must listen for a request that could meet the FMLA criteria, as employees are not mandated to specifically request FMLA leave to be protected by the law. During the leave, managers are to contact employees to remain informed of changes and communicate this information to HR. Additionally, managers must follow FMLA privacy, confidentiality, and record-keeping responsibilities. The Equal Pay Act prohibits sex-based wage discrimination between men and women in the same establishment who perform jobs that are substantially equal. While you are not responsible for compensation decisions for employees, managers must ensure that if employees are performing the same job or the jobs are substantially equal, that they are paid equally. You should know your employees' roles, level of responsibility, skills, and essential functions so that if you were faced with a claim of disparity in pay, you could give an appropriate reason for the difference. If you could not provide an appropriate reason for the difference, then HR should be consulted to assure fair pay is attributed as appropriate by law and by company policies. If you receive a complaint from an employee regarding a wage issue or pay discrimination, please take it seriously and immediately refer it to HR. Occupational Safety and Health Act of 1970, or OSHA. These are the regulations designed to protect workers from work-related hazards, injuries, or death by mandating that employers provide a safe workplace. It is our job as managers to ensure that our workplace is free from hazards and to involve employees in an effective safety management plan. Under OSHA, an employer must follow all relevant OSHA safety and health standards, find and correct safety and health hazards, inform employees about chemical hazards through training, labels, chemical information sheets, and other methods, provide required personal protective equipment at no cost, keep accurate records of work-related illnesses and injuries, post OSHA citations, injury, and illness summary data, and posters where workers will see them. Employees' rights under OSHA include working conditions that do not pose a risk of serious harm, receiving information and training about chemical and other hazards, methods to prevent harm, and OSHA standards that apply to their workplace in a language that the worker can understand, to review records of work-related injuries and illnesses, and to get copies of test results done to find and measure hazards in the workplace. As a manager, it is imperative to make sure that the work environment is free of hazards and to ensure that your employees have the appropriate training and protective equipment needed. All accidents or incidents must be investigated, properly reported, and documented carefully by you to ensure we maintain OSHA compliance in the workplace. Lastly, regarding OSHA, an employee has the right to file a complaint, the whistleblower's rights. Employees may file a complaint and ask OSHA to do an inspection with the request for confidentiality. Because it is an employee's right to contact OSHA, managers must not give an employee any reason to fear retaliation. The National Labor Relations Act, or NLRA, promotes collective bargaining between labor and management and ensures workers the rights to organize and join a union. Under the NLRA, Section 7, employees have the right to form a union among coworkers, join a union, assist a union to organize, go out on strike for better working conditions, and refrain from union activity. Unfair labor practices in Section 8 of the NLRA forbid an employer to interfere with, restrain, or coerce employees in the exercise of the rights guaranteed in Section 7. As a manager, some of the things you must not do in regard to union activity are threaten employees with loss of job or benefits, threaten to close down the company, question employees about their union activities, spy on union gatherings. To put it in a nutshell, it is illegal for an employer to discriminate in employment because of an employee's union activities within the protections of this act. Well, that concludes today's training course in basic laws. I hope each of you enjoyed this Employment 101 presentation. I want to remind you that our company expects each of you to follow the laws and company policies to protect our employees and this company. Should you have any questions, please set up an appointment with HR. And remember to document, document, document. It is your responsibility to keep careful records for each employee you supervise. Thank you all for your attention and participation today.